Well, thanks for having us. I mean, the Attorney Action Club has added a lot of value to me and our practice over the years, both in terms of what we learned substantively from the presentations and also just the group dynamics and getting to know attorneys better. And a lot of us are going through very similar things in terms of starting a practice and growing a practice and the joys and headaches of running a law firm. This group's been a big support network for us as well. So thank you for having us today. We're going to be talking about the Corporate Transparency Act. It's a new law that just went into effect January 1st. We feel that a lot of people don't know anything about the Corporate Transparency Act. It affects just about every business that's out there. There are some exemptions that we'll be talking about today, but the vast majority of the clients that we help out, the small business owners, it affects virtually every single one of them. We're going to start off just a little bit of background about myself, about Matthew, and about our law firm, so have an idea about where we're coming from, what kind of companies have to report, underneath the Corporate Transparency Act, and when do they have to report, what's included in the report, who's included in the report, the different tests that are involved in terms of not only the owners of the report that have to be included, but also people that don't own any equity in the company sometimes have to be included in the report. The types of very, very strict penalties are involved if you're not complying with the Corporate Transparency Act. Some very stiff penalties that are, in our view, pretty extreme. We'll go over some of those penalties as well. And it's not just a one-time reporting requirement. There's ongoing obligations depending on what changes are going on in the business. And so letting you know when additional reports may be required for your business, and some of the kind of reporting ins and outs in terms of FinCEN identifiers. And then lastly, we'll kind of round up on additional compliance considerations. By all means, during the presentation, ask questions in the chat. We're happy to answer as we go along. I think that makes it a little more dynamic than just us preaching the whole time through for the next hour. So a little bit about myself. I grew up in Nebraska. For some of you guys, this might be the only Nebraskan you've met. That puts a lot of pressure on me. I'll do the best I can to be a nice Nebraskan. Went to high school there, grew up there. My folks are still back in Nebraska. When I came to come to college, I wanted to, experience something very different. So left Nebraska, went to Iowa, something very, very different from Nebraska, of course. So went to college in Drake University in Des Moines, Iowa. Went back to Nebraska. I got a master's in political science at the University of Nebraska. Worked for a congressman for a couple of years in Washington, D.C. He represented the Chapel Hill area of North Carolina, doing a lot of small business policy issues, a lot of budget policy issues, a lot of tax issues on the House side of Capitol Hill. I went to law school at Georgetown. After Georgetown, I clerked for 2 years, 1 year with the State Supreme Court in Nebraska. Wasn't quite ready to do the law firm thing. So my second year, I clerked in St. Croix in the U.S. Virgin Islands. Highly recommend that. Anyone has a chance to clerk anywhere, especially on an island, I recommend that for people coming out of law school to take a heavy look at. Went to New York City, practiced a large law firm in New York City, and then finally moved out here in 2010. My brother went to business school out here at Cal, visited a bunch, felt this is much more my speed than New York City was. And so I've been really happy living in the Bay Area. We're still in San Francisco, both my family and my business in San Francisco. We haven't fled yet. I think a lot of people fled San Francisco. We're still here, so both live and work here in San Francisco. So a little bit about Matthew. Matthew is a California native. And he went to college in Chico and got his JD from Mississippi School of Law. Both Matthew and I, we focus on helping out small business startups. And Matthew is our firm's Corporate Transparency Act guru. So when this came out, we very quickly realized that this would be impacting virtually all of our clients and wanted to kind of a designated go-to person in the law firm that would really dig deep on the Corporate Transparency Act to be able to advise our clients on the act, who has to comply, who has to file, who doesn't have to file, and kind of the nuances that go in with those filings. And then before we jump into the Corporate Transparency Act, just a little bit about our law firm. We're now 8 full-time attorneys, W-2 attorneys, focused on helping business owners. About half the practice is transactional work, setting up over 50 new companies a year, outside counsel on contract drafting, raising capital, commercial leases. I also have a real estate broker's license, so I do some transactional work in terms of helping people buy and sell their properties. When they find the buyers themselves. We have a full-time trademark attorney on staff, Vivek. He files over 100 trademarks a year. Robin does a lot of M&A work, buying and selling companies, dissolving companies. And then the other side of the practice is business disputes, both in terms of representing employers when the employees are filing claims against them, and also a lot of co-founder disputes. Companies are owned 50-50, and it's all rainbows and sunshine when they start out, of course, but then those always end up that way. Breach of contract disputes, so that's the other side of the practice. The transactional side, I call that the happy law. So we do the happy law side, and the dispute side, the not so happy law side. So we do both sides of it.
And I guess I'll be taking over from here. Thanks again, everybody, for taking the time to listen to our presentation. It's my first time getting to meet with you all, and I'm real excited to share with you guys the exciting world of the Corporate Transparency Act. So to start off, what is the Corporate Transparency Act? Well, it's a federal law that was enacted in 2021, and that went into effect this year in 2024. It was introduced as part of the Anti-Money Laundering Act of 2020, and essentially its purpose is to create a database of beneficial ownership information within FinCEN, which is the Financial Crimes Enforcement Network of the U.S. Department of Treasury. And this database is going to be used to provide the resources to combat tax fraud, laundering, and terrorism. So it has a pretty noble purpose, stopping any types of illegal activity from abusing, our corporate formation process. But on the other end, it also creates, a lot of obligations on nearly every small business, and that's something that we're going to be talking about a lot today. So generally, the first question I have from every client that has to submit a beneficial ownership report is who's going to have access to their personal information. And we're going to go further in depth into all the personal information you have to give up. It's not a ton, but it's definitely stuff that people don't really want laying out there. And so upon request, FinCEN is going to permit federal, state, local, tribal officials, as well as certain foreign officials to get this information as it relates to national security, intelligence, and law enforcement. And financial institutions are going to have access to this information so long as there's consent from the reporting company. And FinCEN has represented that this information is going to be stored in a secure, non-public database. So it's not like someone can go to the directory, just anybody off the street can just go on the directory and find out all this personal information about an owner. And also, one preliminary issue too is that there's been a trial court ruling surrounding the Corporate Transparency Act, and actually a U.S. District Court and the Northern District of Alabama ruled that it was unconstitutional. And for all of you constitutional law buffs out there, the reasoning that the court had was that the CTA, Corporate Transparency Act, exceeds Congress's enumerated powers, and that Congress isn't authorized under the Foreign Affairs power, the Commerce Clause, or the taxing powers to basically have this legislation. But the trial court judge was very specific to make sure that this injunction against the government only applied to the small businesses associated with the NSBA. So unless you're representing a company who is currently a member of the NSBA, FinCEN maintains that it still reserves the right to enforce this against any other reporting company.
Hey, Matthew, we've got a question in the chat.
Yeah.
Are LLCs used as holding corps exempt?
We're going to get into that. It really depends on the reporting company itself. I'm going to say generally no,
Okay,
but there may be an exemption that applies, and we'll get to that coming up. So pretty much this whole presentation, we're going to be really drilling down into this statement right here. Is every reporting company must file a beneficial ownership report that identifies each beneficial owner of the company. So this begs two questions, right? What's a reporting company, and what's a beneficial owner? So to start off with what a reporting company is, it's going to be really any entity that's created by the filing of a document with the Secretary of State or similar office, depending on the location, depending on the state. So think your LLCs, your corporations, your professional corporations. What this doesn't include is going to be your sole proprietorships and your general partnerships, usually, right? I've never done any corporate formation in Delaware, so some of you may know this better than I do, but to my understanding, I think to form a general partnership in Delaware, there needs to be a formation document filed with the Delaware Secretary of State. Feel free to correct me if I'm wrong, but if that's the case, that's going to be considered a reporting company for purposes of the Corporate Transparency Act. And also, whenever it's formed under the when an entity is formed under the law of a foreign country and registered to do business in the U.S., the filing of that document with the Secretary of State is the trigger for whether or not it's a reporting company. So with the Corporate Transparency Act, trusts that kind of play a unique role. First off, a trust is not going to be considered a reporting company, but as we'll find out later, a trust does have a role to play in a beneficial ownership analysis. But again, generally, there's no document that needs to be filed with the Secretary of State in order for one to create a trust. Again, I think Delaware special. I think I've heard down the grapevine that to create a trust that's recognized in Delaware, that something needs to be filed with a formation document needs to be filed with Delaware. And if that's the case, then I think in that context, it's going to be considered a reporting company. And again, this is a pretty new area of law, so there's a lot of kind of like the Wild West. There's nothing totally solidified yet, and there's quite a bit of ambiguity, which kind of makes it an exciting topic to talk about. So we know what a reporting company is generally now. So there's this long list of 23 exceptions, and these types of companies, even if it fits the requirements of a reporting company, if they're this category of a business, then they're not going to be considered, they're not going to be obligated to provide a report. So, this includes like a securities reporting issuer. It can include banks, credit unions, venture or capital fund advisors, pooled investment vehicles, accounting firms, insurance companies, tax exempt entities. And the three I'd like to really highlight, because I think it's going to come up more often than any of these other types of exemptions, is going to be the large operating company. Number 21, number 22, the subsidiary of certain exempt entities, and lastly, inactive entities. So this is why really the Corporate Transparency Act applies to mostly small businesses, right? Is because if you're a large operating company based on these three prongs of this test, you're not obligated to report. So the first one is if the company employs more than 20 full-time employees in the United States. The second is if it has a physical office in the United States. And lastly, if it's filed when it's filed a federal income tax or information return in the U.S. for the previous year, showing more than $5 million in gross receipts or sales on their Form 1120. They're going to be, assuming they meet all three of these requirements, it's going to be exempt from having to file a report. All three of these requirements need to be continuously maintained, though. So if they don't meet that gross receipt threshold for a year, or they only have 18 employees at a given time, they're going to lose their exempt status and they will need to report like all the other small businesses would. And then next, also, what's interesting is any subsidiary of that's wholly owned by an exempt entity, they're also not going to have to report, which makes sense, right? However, like with any fun piece of law, there's an exception to the exception, right? So if the subsidiary is wholly owned by one of these usually exempt entities, that subsidiary is still going to need to file the beneficial ownership information report. And that's if it's wholly owned by a wholly or partly owned by a money service business, a pooled investment vehicle, entities assisting a tax-exempt entity, or inactive entities. And I can understand why, if it's wholly owned by an inactive entity, the subsidiary would still be required to report. I don't really understand the policy. If anybody wants to chime in as to why, if it's wholly owned by a money service business or a pooled investment vehicle, why they would still have to report when, say, if it was owned by, a different exempt entity, they wouldn't have to report. So that's something that I haven't gotten to the bottom of yet. But if anybody has any thoughts, I'd be happy to read about them. And then lastly, inactive entities do not need to report. And this makes sense, but we have to make sure we're using FinCEN's definition for an inactive entity, not our own definition. So according to FinCEN, it's considered inactive if it was in existence before January 1st, 2020. It's not currently engaged in active business, is not owned by a foreign person, directly or indirectly, wholly or partially. It hasn't experienced any change in ownership during the last 12-month period. It hasn't sent or received any funds in an amount greater than $1,000, either directly or through any financial account in which the entity or any affiliate of the entity has had an interest during the last 12-month period. And lastly, it can't hold any type of assets, whether in the US or abroad, including any ownership interest in any corporation, LLC, or similar entity.
Matthew, it just strikes me, looking through the 23 exemptions, the type of active lobbying that must have been going on in DC while the legislation was working its way through the legislative process, the regulatory process, and each of those exemptions, there's a reason they're there. There's some people probably spend a lot of money to get in there, right? So
yeah. So now I've decided who needs to report or what companies need to report. Now we need to talk about when they need to file these reports. So it's going to depend on when the company was formed. If the company was formed after January 1st, 2024 and before 2025, so this year, or registered to do business in the US during the same time period, they have 90 days to file their beneficial ownership information report within the earlier of when that company received actual notice of the company's creation. So a letter from the Secretary of State, confirmation letter, or depending on the state, after the Secretary of State provides public notice of its creation or registration, whichever comes first.
And I think with these two deadlines, what we're finding out quite a bit is that, for our clients that were formed before January 1st of this year, more of them are finding out about this requirement, either through their CPA or reading different articles. The deadline for the companies that were formed after January 1st this year, when they only have 90 days to file their first report, that's a really tight deadline. It's a relatively narrow window of time where people have to know about this reporting requirement to submit the report. Often new business owners, they're juggling a lot of different things and a lot of different requirements. And so for them to find out about this requirement within 90 days and to submit the report within 90 days, I think it's a really easy deadline, particularly for the new companies to miss.
Yeah. And as we'll talk about later, if it's formed or here in a second, if it's formed after 2025, the deadline gets even tighter, right? But backtracking a bit, if it was formed before 2024, they're going to have up until the end of the year to provide their beneficial ownership reports. So at Ben Law Group, we're pretty much preparing for, the apocalypse that's going to happen on December 30th, when all of our clients who we've informed them back in February, March, of this requirement, are going to say, hey, we need to get this done now. And we're going to just take that head on when it happens. But
New Year's Eve party, right, Matt?
yeah, I'm really looking forward to it. And then, also after 2025, that 90-day grace period gets trimmed down to 30, right? So companies formed after January 1st, 2025 are going to have 30 calendar days from notice that their entity was created to file the BOI report. And so it kind of begs the question, if an entity or if a law firm handles formation projects, it may be best to just include filing the beneficial ownership report concurrently, right? So now we're going to find out we're going to talk about the information that's going to have to be disclosed to FinCEN. So The beneficial ownership report, once we have identified who's going to be the beneficial owner, it's going to disclose the following: their full legal name, their date of birth, their current address, and also their unique identifying number that's attached to either their unexpired passport, driver's license, ID, or foreign passport. Or
Matt, is my
yeah.
recollection right that the address, that's a home address, is that right?
Yeah, it is their home address. So it definitely feels like you know, an invasion of privacy for, you know, the people that aren't doing anything improper, you know, just trying to run their own small business. So what I usually have my clients do in the alternative is they can obtain a FinCEN identifier, and they're going to get this by basically delivering FinCEN the information that's going to be on the report anyway, but that stops them from having to send any information they're uncomfortable with sending it over to me, right? And they can't have a data breach if I was never in possession of it in the first place, right? So I usually try to push my clients to get themselves a FinCEN identifier, and then I'd file the report with the FinCEN identifier. And so now we're going to get to the most exciting part of this presentation, is we're going to figure out who a beneficial owner is. So there's two tests. The first is if an individual owns or controls not less than 25% of the ownership interest of the entity, or the second test is if they exercise substantial control over the entity. So the first test is the 25% or more ownership interest test. And this is going to include all categories of security that might be issued by a reporting company. And this includes options and convertible securities. So if there's really any way to calculate that somebody has a 1/4 interest in the entity, they're going to meet this test. And this is going to, you know, it's going to include anything classified as stock or that confers voting power, any capital or profit interest, any convertible instrument, any put, call, straddle, or other option. And just to be totally cohesive, FinCEN made sure to add this catch-all, right? That any other instrument or contract used to establish ownership. So there's that pretty much gets rid of me, you know, trying to create an ownership interest from any other way than what's listed up there. You know, you can't say I got you to FinCEN, right? And beneficial ownership, when we're assessing this 25% test, it's calculated both directly and indirectly. So the reporting company is going to have to calculate all the ownership interest an individual owns, both directly and indirectly, through any contract, arrangement, understanding, relationship, or otherwise. And, you know, this comes up when, say, there's joint ownership over an ownership interest. It's not treated as, you know, or that they split it in half, and now, you know, I don't have 25% of the company anymore. If we have two joint owners that own 30% of, you know, an entity, and they're not going to say, well, we have 15 each. Now they both own 30%. So they're both going to be beneficial owners. So whenever we have an intermediary, and this comes to the question that we heard earlier for a holding company, right? You're going to have to report the individual ownership interest in the reporting company held through ownership or control of one or more intermediary entities that separately or collectively own or control ownership interests of the reporting company. So really, you know, FinCEN doesn't have an interest in the holding company, right? You got to kind of pierce through that and go directly to who indirectly owns the reporting company. And we'll go through an example right now. So we have 4 25% members of Reporting LLC. That's the name of the LLC. X, Y, Z, and Holding Company Inc. are the 4 members of the LLC. Holding Company Inc. has 2 50% shareholders, A and B. So X, Y, and Z are going to have to report because they have at least 25% ownership interest, right? However, A and B only indirectly own 12.5% of the reporting company through their respective interests, right? So they're not going to have to report under the ownership percentage test. Now, this could be different. Say if we only had 3 owners, right? X had 25%, Y had 25%, and holding company owned 50%. Well, now A and B indirectly own 25%, right? And now they're going to be considered beneficial owners that need to report. And so now we're back to trusts again. And this is something that my clients have not taken too kindly to, because, you know, a lot of times when people form trusts, it's usually for their privacy, right? But assuming that the trust fulfills this requirement of the 25% test or the substantial control test, then either the settlor, beneficiary, or the trustee is going to have to report on behalf of a trust that's a beneficial owner. And it depends on the setup of the trust, whether the trustee, the grantor, or the beneficiary is going to report. I'd say this is the most common one, is if the trustee is required to report. The trustee is required to report if the trustee has the authority to dispose of trust assets. And as far as I know, that's pretty much every trust, right? So the trustee is going to have to report in most instances. Now, if it's a revocable trust, then the grantor or settlor is going to have an obligation to report as well. And the beneficiary is going to have an obligation to report if he or she is the sole permissible recipient of the income in principle, or if he or she has the right to demand a distribution or withdrawal substantially all the assets from the trust. So really, when determining who in relation to a trust that's going to have to report, it goes by who has the most control over the trust, and it's not mutually exclusive. I mean, you can have you know, the trustee and the grantor be individuals that need to report. And then as we near the end of this 25% test analysis, all beneficial ownership has to be calculated on a fully diluted basis. So the reporting company is going to have to calculate its outstanding ownership on a fully diluted basis at the present time, and with any option or similar interest of the individual being treated as exercised. So in plain words, it's we kind of have to act like the trigger that created this present, that's going to create a future, the future entrance into a present interest of the ownership interest. That trigger's already happened, right? As far as determining whether or not someone has 25% interest or not. And, you know, this gets complicated because a lot of people have, or a lot of entities have anti-dilution rights, right? Which kind of goes against the whole point of that.
Matthew,
yes.
on the prior slide, are you referring to a trust that's connected to a corporate entity or a standalone trust?
Not a standalone trust, a trust that's an owner of the reporting company.
Okay.
Yeah. A trust isn't 99% of the time isn't going to be considered a reporting company. This is just in the context of the trust having the ownership interest of the reporting company.
So if an LLC has the 100% beneficiary a trust, that's when the trust has to report.
Yeah. If it meets the 25%, as long as the trust owns over 25% or more of the entity. And also there's a separate test also that we're going to get into called the substantial control test. If the representative of the trust has substantial control over the entity, then the trust is going to be obligated to report via one of the individuals connected to the trust.
Thank you.
Yeah, no problem. So yeah, and as you know, this doesn't happen a ton with small businesses, but you know, we can get into some pretty complicated ownership structures of, you know, when you know, a shareholder owns, you know, preferred stock and a separate series of common stock, you know, and it gets complicated to determine if they actually have 25% or more, depending on how you interpret it, right? So if we ever get into a situation where we're unable to produce a calculation with reasonable certainty, according to FinCEN, then they have a fail-safe rule. So we're not getting off the hook. The reporting company should calculate an individual's ownership percentage of the reporting company based upon the individual's ownership of any class or type of ownership interest. So any individual who owns or controls 25% or more of any class or type of ownership interest of a reporting company shall be deemed to own or control 25% or more of the ownership interest of the reporting company as a whole. So this really comes down to if I own 25% or more of, say, preferred stock, right? I'm going to be considered 25% or more or more of an owner of the entire entity if it comes down to if we ever have the excuse that we just can't reasonably come up with what my actual share is. They really drill down into just looking at the type of stock at that point. And this is just a quick recap slide. All forms of ownership interests are considered for the 25% test. Intermediaries are ignored. They're after the individuals, so they're going to ignore any holding companies. Depending on the structure of the trust, it's going to determine whether the grantor, settlor, beneficiary, the grantor, trustee, or beneficiary is going to report. And everything needs to be considered on a fully diluted basis. And then one interesting rule that we get to here also is if, we had that exemption earlier that we talked about. If a subsidiary is wholly owned by an exempt entity or entities, this is the one instance where the owner entity is what actually submits itself as a beneficial owner. We don't need to get to an individual. It's just when a subsidiary is wholly owned by an exempt entity or entities. But this rule goes out the window if there's just if an individual or a non-exempt entity holds at least 1% or one share of the entity, the reporting company, then they're going to have to report the entire, or their a traditional beneficial ownership report. And this part's also pretty interesting as we talk about substantial control, because it's a little counterintuitive, right? When you hear about somebody saying, "Hey, I'm an owner of, I'm going to be a beneficial owner of this company," you think they actually have an ownership interest, right? They have equity in the company. Well, this rule throws that out the window too. It turns out you don't even need to have an equitable interest in an entity for you to be considered a beneficial owner. So FinCEN describes substantial control as if you're a senior officer of the reporting company. So if you're the CEO, the CFO, the managing member of a manager-managed LLC, you're going to be a senior officer in that case. And even if you don't actually have a membership interest or an ownership interest in the entity, you're still going to be considered a beneficial owner to FinCEN. So anyone having authority over the appointment or removal of officers or directors, that basically means generally every director is going to be considered a beneficial owner because they have the power to appoint or remove officers. And you can even get into some arguments that a majority shareholder, which usually they'd be covered in the 25% test. But now we're even talking about shareholders who have the power to remove or put in directors. Now they're going to be considered to have substantial control. And again, we're still in the Wild West area of this law. Nothing's been totally founded yet. We're still looking forward to more regulations, more case law interpretations. But at the moment, we have some ambiguity here of who's actually exerting substantial control or not. Right? So, and the other two prongs are if whoever has substantial influence over important decisions of the reporting company, and any person who has any other form of substantial control over the reporting company. So that last prong, they're talking about Al Capone, someone who's money laundering. He has absolutely nothing to do with it formally, right? He's just the one that's whispering in everyone's ear of how to run the entity and conduct its legal activities. Well, that prong is what gets him. So in theory, he's going to turn himself in, right? He's going to submit his beneficial ownership report and say, I have involvement in this. So I don't think that'll actually happen, but in theory, right? So even if someone meets all the requirements to be an individual that needs to submit a beneficial ownership report, there are some exclusions. For example, a minor child, they're not going to need to report so long as their personal information, so long as they have a parent or guardian that can substitute it. And if the individual is acting as a nominee, intermediary, custodian, or agent on behalf of another individual, they're not going to need to be considered a beneficial owner. That usually covers outside counsel for a company. This is what kind of stops us from having to file a beneficial ownership report, because if you look at prong number 3, outside counsel giving legal advice, that sounds like substantial influence over a decision that the CEO or someone's going to make, right? So now all of a sudden, without that exclusion on this slide, outside counsel would need to be considered a beneficial owner, right? And also, the third prong is just a long way of saying employees that aren't officers, they're not going to be considered a beneficial owner that needs to report. An individual who's only has a future interest opposed to a present interest in their ownership, they're not going to be considered a beneficial owner until that interest vests. And lastly, even though a creditor can have a lot of say over, or a lot of substantial influence over a company and its direction, they're, by virtue of just being a creditor, they're excluded from being a beneficial owner. And then lastly, this is also really important for firms that handle entity formation, is that any company that's formed after January 1st, 2024, they're going to need to include a company applicant in the beneficial ownership report. And who's the company applicant? That's the individual who actually submitted the formation documents to the Secretary of State. Usually that's going to be one of the owners, right? But sometimes it's your client's brother-in-law, and now we got to track him down, and he's got to be considered a beneficial owner, right? You can see how that can get kind of complicated. And also, if your firm handles formation work, it's usually an attorney at the firm who submitted this formation paperwork to the Secretary of State, right? So that means that attorney is going to be considered the company applicant when that client comes in to do their beneficial ownership report. So what we've been doing at Bend Law Group is all the attorneys at the office that handle formations, I've gotten them to get their own FinCEN ID, and I submit their FinCEN ID opposed to having to get all their personal information for every beneficial ownership report that I have to do that requires a company applicant. And the company applicant's going to need to provide similar information to FinCEN, their name, date of birth, but they can use their business address opposed to a beneficial owner needs to use their residential address. And same thing, we need to have an identifying number on their driver's license, ID, passport. So with that said, I'm going to hand things over to Doug, and he's going to talk about some of the penalties for noncompliance.
Yeah, Matthew, before we get into that, I guess, one of my big concerns with this law is identity theft, right? And really in 2 different ways. I know there was an alert that FinCEN put out recently, essentially warning people, hey, if you're getting solicitations asking for your personal information, saying it's for Corporate Transparency Act compliance type reasons, be careful. I know that they're supposed to keep it in this secure database, but I have to think that this is going to be a target for hackers. You have this database of very personal information about virtually every small business in the country. It's something that I'm genuinely concerned about and how this is going to play out.
Yeah, I'm concerned about that too. And they just want us to take their word on it. That it's going to be totally safe. So it's definitely a concern.
Another concern of mine is the penalties for noncompliance. Let's get into this. It's very, very steep, right? So you're talking about for noncompliance, there's a civil penalty of $500 per day for not filing this beneficial ownership report. Potential, time in jail for not filing these reports. Some very, very stiff penalties, and particularly, as I mentioned before, our clients are forming new entities within 90 days. You're not filing this report. You're looking at penalties of $500 per day, and then next year for new entities, after 30 days, $500 per day. I mean, these are new companies that are dealing with a lot of new obligations. They're trying to figure things out. Often they're very tight on resources. So I know on the one hand, they need to have penalties in place to make sure that people actually file these reports when they may be reluctant to do so, given the types of information that's included in the reports. But on the other hand, when I look at these penalties, it seems to be very, very punitive to me. And Matthew mentioned earlier in the presentation that, we're anticipating, particularly as the end of the year creeps up, that there's going to be more and more media coverage, perhaps, and articles that are going to go out. They're kind of flagging this for business owners, saying, hey, if you don't file this by the end of the year, these are the kind of penalties we're going to be looking at next year. And there's going to be a flood of people trying to figure out what they need to file and how they file it. And the other item too is like, when do you actually have to, amend the report? It's not like it's one and done where you file the report and you don't have to ever file a subsequent report. That might be the case for some businesses that don't have a lot of change in their business. I think a lot of the people on this call, they may, be the only shareholder in their business for a long time and not forever. But for a lot of businesses, you do have changes in terms of, who owns, at least 25% of the company, who has substantial control over that company. If there's changes in different identifying documents, and Matthew can get into that, but that's a whole other reason why you might have to file a subsequent report. And then the other big one is changes of business names. So we see that quite a bit where, a business starts out as one business name, and for marketing purposes or other reasons, they decide to change their business name. Matt, could you talk a little bit more about the change in image of identifying documents? I know that's something that's been a concern of ours as well.
Yeah. So what FinCEN has basically said is if there's ever been, the way I think of it when they say if there's a change to the surface of the identifying document, I think of if it expired and you had to get it renewed, right? Technically, there's going to be a few changes there. If anything, the next expiration date is changed. So, I mean, hypothetically, if you wanted to be very, very compliant, have absolutely no chance of being in violation of this, then, once your license is renewed or your passport's renewed, you're probably going to need to file a subsequent amended report. The good news is that it doesn't cost anything to file these reports. So you can just submit it on their website, but it gives you something that you have to kind of be on the lookout for at all times, right?
And I guess there's so many ways that people could be in non-compliance with this thing. I mean, if you look at prong number 3 here, change in data for parents and legal guardians of excluded minors. I think a lot of people, when those changes are happening within a family, they may not be thinking about Corporate Transparency Act compliance, right? So I think that the lack of really exposure about people knowing about this law, about the stiff penalties of this law, about the number of ways that people can be in noncompliance, and about the very broad blanket of businesses that it covers and beneficial owners that it covers, is very expansive and for me, very concerning.
Yeah, and one thing that I forgot to kind of add to the PowerPoint that I also wanted to talk about is whenever you need to make an amendment to correct a prior report, say there was a mistake, you're gonna have 30 days from when the reporting company first became aware of or had constructive notice, had reason to be aware of this mistake. And once you've been notified, whether it be actually or constructively of this mistake, you have 30 days to make the revision.
I mean, the other trigger we're seeing quite a bit too is, with the sale or purchase of a business, right? So if you buy a business, you're probably having a change in the beneficial owners of that business, and you're having to file within 30 days this report, to be in compliance with the Corporate Transparency Act. And when somebody's buying or selling a business, that's the last thing that they're thinking about right now. So we talked a little bit about this before, about how we're helping our clients navigate this. And one of the key steps that we're recommending really for all of our clients is for them to get this FinCEN identifier. Essentially, you input all the data once, and you get this identification number that you can then share with the company instead of all your personal data. And so if you're a beneficial owner, or if you have substantial control over a number of entities, you can provide them with this number instead of your home address and all this other information that you would normally need to provide with them. So I think if you yourself have to submit a report, or if you are a beneficial owner or have substantial control, getting a FinCEN ID both for yourself and for your clients is something that we highly recommend. So on the compliance side of things, this is some of the stuff that we're, recommending our clients put in place. For us, we help set up over 50 companies a year. So one thing that we're implementing is that for every company we set up, we have a separate email that goes out to them that notifies them about this requirement, notifies them how can they file, when can they file, when they're required to file. We do a lot of entity maintenance for our clients. We're reaching out to all those clients. We're working our way through the list of hundreds of clients we've helped out over the years to notify them of this requirement. We've been doing it all year. We'll be doing it up until the end of the year. But for particularly the attorneys on this call that have clients that are business owners and are businesses, this is something that we recommend that you reach out to them on and flag for them and make sure they know the requirement and help them submit the report if they ask for help.